SJC-13283, U.S. Auto Parts Network, Inc., v. Commissioner of Revenue.
Okay, Attorney Green, good morning.
Good morning, Your Honor. May it please the Court, Assistant Attorney General Julie Green for the Commissioner of Revenue. The essential issue in this case is which constitutional standard governs this Court's review of the assessment at issue, the standard of Wayfair or of Quill. The Appellate Tax Board committed error when it declined to apply Wayfair, mistakenly believing that the doctrine of retroactivity is limited to the facts of Harper and Beam, where a court declares a tax scheme to be unconstitutional.
Can you answer a question that I should know the answer to? It's perhaps overtly simple. We have the physical presence standard. The DOR imposes a different regulation, which is more than the physical presence in anticipation, I guess, of internet contacts. So why is that regulation imposed when there was already on the books the physical presence standard?
I think I disagree with both parts of that, and maybe I'm not understanding your question. So first, the regulation was
That's
not
on me,
different.
but go on and go on and
Well, let me make sure I answer. First of all, the regulation was not broader. The regulation was not attempting to go beyond the physical presence standard. It was applying the physical presence standard, interpreting the internet, the facts of the internet, differently than anyone had looked at them before.
But cookies of physical presence?
Cookies, downloaded software, and very importantly, use of content distribution networks, CDNs, which are physical server farms that sit in Massachusetts.
No, I got the third, but the first two, the apps and the cookies, I'm not getting the physical part of that.
So let me submit that is no longer a live question, but I can answer it for you, which is that the Commissioner's computer science expert, Professor Miller, explains in his declarations that the way those work is that electrons physically on a consumer's device, a computer or an iPhone, for example, that the electrons physically take up charge space. It's an actual physical process that operates physically on your device in a way that does constitute physical presence. It's also important to understand the body of case law that has developed over the decades of the physical presence standard. Physical presence does not necessarily mean a tangible object. It can consist of a lot of different types of things. And a very good example is the case called Overstock.com, in which click-through nexus sales arrangements were held to be physical presence, where Amazon contracted with residents of a state who hosted websites to put an Amazon link on their page, and every time a consumer would click on the Amazon link on that other website, the website owner would earn a commission from any sales made by Amazon.
So you started off that answer with saying that's no longer a live issue, and thank the Lord.
Right.
What is the live issue? In terms of the physical presence question that Justice Gaziano had posed.
The live issue is whether the standard of Wayfair is satisfied.
No. In terms of whether or not the regulation fits within the physical presence standard, which was applicable at the time the regulation was issued.
So that's not the live issue, because the live...
But let's just say it was.
Okay.
So you're saying electrons satisfy a substantial nexus to Massachusetts? That was the commissioner's position?
At the time, in 2017, when physical presence was the standard, the position was that those electrons created, among other types of contacts, created physical presence. But when Wayfair was decided, that ceased to be the standard. The standard now in the live issue before this court is substantial nexus. To satisfy substantial nexus, you only need sales volume.
But you weren't applying a substantial nexus. When they taxed his clients, you weren't applying a substantial nexus. You were applying a physical presence requirement. So you didn't, whether Wayfair changes Quill, you were applying Quill. Don't we have to just decide? I mean, you don't get to create a new standard. You were taxing under an old standard.
But this court on review must apply Wayfair.
We
That's
apply
clear.
Wayfair to the federal constitutional requirement about context, but if you were applying a physical presence test and that didn't satisfy physical presence, that's the issue. That's what the tax was based on.
The tax was based on sales volume and the presence of certain facts.
Electrons.
Sales volume plus jurisdictional facts establishing jurisdictional nexus. Since Wayfair, those facts,
But
the electrons,
Can I just, I
are
know you want to
irrelevant.
get to the retroactivity of Wayfair, and that's fine. And maybe you'll get there in the next 9 minutes, but can I, so the regulation doesn't say, we're gonna tax internet vendors, on the basis of whatever is constitutional. Instead, the regulation says, we're going to tax internet vendors on the physical presence of the Dormant Commerce Clause standard as set forth in Quill. So the state or the commissioner has made a decision to limit its taxing authority to whatever Quill articulated as the standard. And so I'm, given that limitation, self-imposed, why is physical presence satisfied by electrons?
I disagree with the premise. Can I address that first? The basis for the tax is sales volume. The tax rule is if you have more than $500,000 in sales in 200 or more transactions, then you must collect the tax. The physical presence standard comes into it only to explain the jurisdictional nexus that needs to also be satisfied. The jurisdictional nexus is satisfied if the taxpayer, if certain facts are present. That is to say, does the taxpayer have any of these three internet contacts?
No, I have to say, I really don't understand that. Quite frankly, what I'm interested in is if the regulation is tied to Quill, then what's the constitutional analysis matter? The regulation is tied to a standard. A regulation can tie itself to an old United States Supreme Court standard. And if you couldn't, I'm not saying that it's not ambiguous, but if it is clear, then it's Quill that is the vehicle that we look to see if the tax is appropriate. Said more simply, if the regulation is based on Quill, then we apply Quill and we don't have a constitutional concern.
I disagree with that because that's not what this regulation says. The regulation does not say you have to pay tax if you have physical presence. And by the way, here's what we think physical presence is. I think that's how U.S. Auto is reading the regulation. But what the regulation says that the operative legal command of the regulation is if you have more than $500,000 in sales in 200 or more transactions, then you must collect the tax. You are exempt if you lack any of these three contacts. In other words, the three contacts are there because they establish jurisdictional nexus, just like minimum contacts establish jurisdictional nexus with a court. The court can't order anybody to do anything without those facts of minimum contacts being present, but that doesn't change what the order is. The clear command of the regulation is if you meet the sales threshold, then you must collect the tax.
All right, let's say I disagree with you and I'm actually reading the regs, which actually call upon Quill. How do these three things satisfy physical presence under Quill?
Okay, if you apply Quill, and I want to be clear, I
I
don't
think
believe
you've
Quill
been perfectly
applies.
clear you're not applying Quill. But
Okay.
let's just assume that I'm going to read the words on the page that say Quill, and that you're suggesting that these three types of electrons satisfy the physical presence. Tell me how.
For the reasons explained by Professor Miller, I'd refer you to his declarations. I think most importantly, content distribution networks, which are sort of physically sitting in Massachusetts, and they sit in Massachusetts in order to facilitate sales.
And do they contain anything other than electrons?
They
I mean,
host
the servers are owned by a different entity, right?
they are,
Yeah,
but they
okay.
host the vendor's website.
And when you say they host the vendor's website, those are electrons?
They're electrons.
Okay.
There's a
So all the
relationship.
physical aspects of the servers, the storage, all that stuff is owned by, not by US Auto?
It's not owned by U.S. Auto, but
Okay, so
physical
all they
presence
do is
test,
license a space, then they fill that space with electrons.
which would be enough to satisfy physical presence. There's a lot of case law involving relationships with independent third parties. For example, you may remember Scholastic Books, where the teacher in a classroom is not an employee of Scholastic Books, but the teacher hands out the Scholastic Books catalogs. That relationship and alone with the teacher, who is not an employee or even an independent contractor, that constitutes physical presence under several cases addressing the issue. Physical presence is a term of art that developed with decades of elaboration. That here the appellate tax board wasn't applying any of the development of what physical presence means. It wasn't looking at those cases, and it short-circuited the entire analysis of Quill by mistakenly concluding that the Supreme Court had resolved the physical presence question in Wayfair, which it clearly did not, because the issue wasn't presented.
Before you run out of time, could you address the retroactivity standard and what tests we should apply and why Wayfair applies?
Okay. The court must apply Wayfair to this situation because the Supreme Court requires that it applies. And I think that really the important issue for retroactivity is that neither the taxpayer nor any of the amici have identified a single exception to the doctrine of retroactivity. No single case where a court refused to apply retroactivity. It's a required feature of federal law, as in this case. The applying Wayfair, you don't evaluate whether the taxpayer had physical presence. You don't reach the question of whether electrons.
The case was on review at the time.
Because retroactivity applies in all pending cases, still open on review, all types of civil cases, without exception. And I know the taxpayer relies heavily on its claim of justifiable reliance on prior law, but I want to be clear that the Supreme Court has considered that type of claim and held that it's not enough to create an exception to retroactivity. Reynoldsville Casket, where the plaintiff, in fact, a very compelling set of facts, the plaintiff filed suit in reliance on a tolling statute, which was later invalidated, and the court in Reynoldsville Casket held that invalidation was worked retroactively so that her entire suit was untimely. And she offered 4 different rationales for why retroactivity should not apply to render her whole claim untimely. And the court rejected each one of them. In fact, it reversed the Ohio Supreme Court, which had refused to apply.
This is my issue with the retroactive application of Wayfair in this particular factual scenario. And when Justice Stevens wrote his Quill decision, he recognized that the physical presence line was a bright line, and one of the reasons he said, I'm going to stick to the bright line, is because of the importance of people settling their affairs and having a reliance interest in the physical presence. Yeah, so it seems perverse to me and I'm going to ask you why it's not perverse, to then say, guess what? We're going to revisit this, and we're going to retroactively apply something that will, by definition, upset settled expectations on the basis of a case that had nothing to do with settled expectations. That is the rule in, and I forget the name of Justice Thomas's decision. What was it? You know, the rule was you can't treat people out of state versus in-state differently, Harper, the Davis case. And that seems quintessentially what the Interstate Commerce Clause is about. But when you set up a rule that's based on bright line expectations, and the reason that that's important is recognizing it's arbitrary. People have to conduct their affairs this way. And then you change that. Why isn't it important in assessing whether or not something should be retroactive, the fact that the rule itself was set up in order to allow a reliance interest?
Because the Supreme Court considered that issue in Reynoldsville Caskets explicitly and rejected it, because that's exactly what the Ohio Supreme Court reasoned in Reynoldsville. It said, this is just unfair. She relied on a tolling statute when she filed her claim, and to retroactively invalidate that tolling statute
But I
would
think
just be
your
unfair.
analogy is different. So if the tolling statute itself had been set up as a bright line rule so that people could conduct their affairs, then that would, the analogy would work. But here, the physical presence rule was set up in order so people could rely on it for tax purposes. And then, you know, Wayfair came along and said, you know what, it doesn't work anymore.
Two answers.
Yeah.
First, there is no bright line exception to the retroactivity doctrine. We have 4 briefs in front of us that had the opportunity to identify any case, any exception. Nobody has identified an exception. Retroactivity is the rule in bright line cases. It's in the rule in tolling statute cases. It's the rule for every case, including this one. The Supreme Court has made that clear. Dozens of cases since 1993 have made that clear. I appreciate why that doesn't seem like a fair result in all cases. But nevertheless, the Supreme Court, Justice Breyer, weighed those considerations back in 1993 and again in 96, and he made clear that is the rule in all cases, no exception. And the second reason, I'll just add, is that Wayfair itself said, look, the Quill rule was intended to be a bright line, but it really isn't. We can see, the court specifically talked about justifiable reliance on bright line rules. And it said, look, at this stage, there is no justifiable reliance on bright line rules because Quill has ceased to be a bright line. It hasn't been a bright line in years. And that's where it specifically referenced Massachusetts regulation. It said, look, people can argue, it's hard to even know how to apply it in the internet world. It's a very unclear rule. People aren't even sure how to apply it anymore. And that's the section of the Wayfair decision where it says that a claim of justifiable reliance is misplaced, or language to that effect. So my 2 answers to your question are, there's no exception to retroactivity. The court must apply retroactivity. It has no choice. I regret speaking of that way, but that's simply the Supreme Court has given courts no choice when they're applying federal law. And the second one is that Quill really isn't a bright line at all, as the myriad cases bemoaning the unclarity of the Quill rule right up to the Supreme Court, where it said the rule is simply not clear at all, have recognized.
I just have one last question, because I'm now confused. So you're saying that the regulation dealing with Quill and Wayfair, all it deals with is the dormant Commerce Clause issue. The power to tax and the tax itself are separate, right? Is that what you're? Because our original questions were focused on, you know, that basically you were taxing under the Quill standard, but I think and you said, no, we got it wrong, and is it because you're saying because our power to tax is set out in the statute related to how much business you do? This reg, which is a morass, is really just a conversation about the Dormant Commerce Clause? Is that what?
No, the reg is not about the Dormant Commerce Clause at all.
Well, is it about the power to tax?
The power to tax, the jurisdictional authority is given by the statute, Chapter 64, Section 1. The sales tax statute imposes a sales tax, and the reg explains how out-of-state vendors, how the sales tax statute applies to out-of-state vendors. It says if you are a large internet vendor over the sales volume, then you must collect the sales tax. And then it explains, well, why can we tax you if you're out of state? We've never taxed you before when you're out of state. And it explains, here's why. It's because there are facts here that create jurisdictional nexus. What are those facts? Those facts are CDNs and downloaded software and cookies. So in other words...
So the fact that if we thought that was wrong, it wouldn't matter, because...
That's right. It wouldn't matter if you thought those facts were insufficient.
Say I think that's just a ridiculous interpretation of Quill, and you were wrong at the time. But I take it you're saying it doesn't matter anymore, even though that was ridiculous, because our power to tax is set out in the statutes, and our silly interpretation doesn't matter. Is that?
I'm saying it doesn't matter since Wayfair, because the constitutional limitation is not physical presence anymore. You don't need those 3 facts establishing jurisdictional nexus, the physical facts. You need different facts now. Wayfair says the facts you need are sales volume. That's enough to create jurisdictional nexus. Nexus looks a whole lot more like minimum contacts for a court's exercise of authority. It's just sales volume. And because there's no dispute that those facts are present here, there's no dispute that this exercise of taxing authority satisfies the only constitutional standard that applies in this case, which is Wayfair, and therefore the court should vacate the judgment of the board and should enter direct judgment for the commissioner.
Okay, thank you very much.
Thank you very much.
Attorney Isaacson.
May it please the court, my name is George Isaacson and I'm counsel for U.S. Auto. The court appropriately, in questioning my sister, focused on the issue of what does the regulation itself stay, which is the more important issue than the issue of retroactivity, which I am eager to address as well. It's interesting to note that on
It's interesting to me that neither of you can agree on the premise, right? She says that the most important thing is retroactivity, and you're saying that the regulation limits the jurisdictional reach of the commissioner. How are we to decide which is the right one?
Your Honor, if we look at the words of my sister in the reply brief, she makes the statement on page 14 that the commissioner is bound by his own regulations. And then if we look at the language of the regulation, the Internet Vendor Rule, it says specifically that the regulation is, quote, enforced to the extent allowed by the physical presence Dormant Commerce Clause standards set forth in Quill Corp. So
if that reg instead said enforced to the extent allowable under the United States Constitution, you wouldn't have an argument?
Well, I'd say then we look to the issue
of the
retroactivity, due process, and the question of what is the applicable nexus standard under the Constitution. But I think the court doesn't even need to reach that question.
Well, yeah, I understand that, but can you answer that question? If the reg instead said, we shall tax you to the extent permissible under the Constitution, is Wayfair retroactive or not?
It is not.
Why?
Justice Breyer, in the Reynoldsville case, the very case that was cited by my sister, points out the fact that you need to look at each case based on its own facts, Now, the cases that have been cited by my sister.
That's not what Harper says. Harper says, you know, when the rule in all civil cases is that our decisions, that is the United States Supreme Court decisions, are retroactive.
What Harper, James Beam, and Reynoldsville are all talking about is discrimination against out-of-state either taxpayers or, in the case of Reynoldsville, litigants. And the court said that there are two manners by which you can correct the problem that exists when there's a discrimination under the Commerce Clause. One thing that you can do
Well, you
is
true up both people, right? You can either refund or you can tax the others.
right. So they said that in order to cure the problem, you can, in fact, treat the favored party the same way you treated the unfavored party, or you can refund to the favored party. The commissioner has cited no case that stands for the proposition that a subsequent Supreme Court case that has changed a constitutional standard regarding the scope of regulatory authority can be applied retroactively to effectively
Isn't the decision
rewrite.
by Justice Thomas? I mean, you're relying on the Souter opinion, right? I get the names confused. Souter talks about difference between right and remedy. Thomas is kind of collapsing the whole thing and saying essentially everything's retroactive. And I mean, it's pretty bold and pretty explicit, isn't it, the Thomas decision? Justice
If you look at
Thomas's
Thomas's decision, if you look at Thomas's decision, for example, his concurring opinion in the Dobbs case.
Rob, I'm trying to avoid more complication, but he seems to say in the civil cases, when we change the rule, it's retroactive. And he doesn't have the sort of nuance that Justice Souter puts into the other case about rights and remedies, does he?
Yeah, I think that's because Justice Thomas does not believe in substantive due process and is eager to go back and
Well,
to
I mean,
revisit
it's
those.
not Justice Thomas. It's the majority decision of the United States Supreme Court in Harper. So what he's saying in that majority decision on behalf of the court is that in civil cases, you apply it to everything on direct, still pending. And this is still pending.
So one of the things that Justice Breyer makes clear, I believe, in Reynoldsville, is that if there is an independent basis for not applying the law retroactively, then that independent basis needs to be evaluated. And it's also interesting that the commissioner acknowledges in his brief on page 16 that, quote, the due process clause embodies an independent principle of law that must be separately evaluated based on the specific facts and circumstances of the case. So in this instance, I think the very point that you were questioning my sister on, the inherent unfairness that is associated with taking a change in a constitutional doctrine, applying it retroactively, so that a taxpayer that was in complete conformity with the law during the relevant tax period is nonetheless subject to a tax liability that it had no way to anticipate, had no prior notice, a clear violation of
Well, I
due-
mean,
of
there
due
was a
process.
published regulation, and they said, the commissioner said, we think these electrons are enough for physical presence. So the notion that your client didn't have any notice is questionable at best for you.
To the extent that Wayfair is the basis for my sister's argument that that should be the case that we look at to determine what is the relevant standard during the time, Wayfair itself makes clear that these electrons and apps do not constitute a physical presence. If I can quote from the Wayfair decision, the Supreme Court said that unless the retailer maintained a physical presence, such as retail outlets, solicitors, or property within a state, the state lacked the power to require that retailer to collect a local use tax. And the court went on in Wayfair to actually identify cookies and apps as being examples of the kind of electronic commerce contacts that are insufficient. It was the very insufficiency of those contacts that warranted the court saying that we are going to overrule the Quill decision, that we can't fit it within Quill, and therefore we will overrule Quill and establish an economic presence standard in lieu of the prior physical
Are
presence.
the CDNs different?
The court pointed out, when it was going through the categories of items that were insufficient, it refers to a website may leave cookies saved to the customer's hard drives, or customers may download the company's app onto their phones, or a company may lease data storage that is permanently or even occasionally located in South Dakota.
That's the CDN?
That is what a CDN is.
Okay.
The court has made clear under its Quill line of cases that the instrumentalities of interstate commerce did not constitute a physical presence. Consequently, a mailbox doesn't constitute physical presence for a catalog company or a UPS delivery driver.
The statute doesn't have any reference to physical presence, right?
I'm sorry, Your Honor?
The statute, I mean, we're skipping over the statute, right? The statute basically imposes this tax on your clients to collect, right? What you're saved by is the Supreme Court's Dormant Commerce Clause, right? The statute applies on its face to your transactional work, doesn't it?
So I think two things, Your Honor. One, when the statute was adopted, there was also a reg that was issued, TR 88-13, that said that it was not going to be enforced until such time as either by federal statute or Supreme Court decision, the state could in fact impose a tax collection obligation on out-of-state companies. And then in the regulation that we're looking at now,
So the statute had that provision in it, that it was unenforceable until what?
no, that was a technical release that the commissioner issued after the adoption of the statute.
Right, but we got to, again, I'm actually, at this point, completely confused, though. So the statute provides for this tax. The TR said, well, we can't do it because of Quill. Then they pass a regulation that says, well, because of CDNs and cookies, we can do it. That's probably wrong under Quill, but then Quill's wiped out, and then we get back to retroactivity. But it's not just that we're interpreting this regulation. We got to look at this whole package, right? The statute, the regulations, retroactivity, everything, right?
Justice Kafka, it absolutely is a whole package.
Yeah.
And I think when you look at the whole package, what you see is that the Commonwealth was interested in expanding the scope of its tax collection obligations imposed on out-of-state companies, recognized the fact that Quill was a constraint in that regard, initially passed a TR that said that they were not going to enforce that regulation. They subsequently promulgated a regulation that said, we have this new theory. We now have a theory based upon electrons sitting on customers' websites. But we also recognize, in the language that I read to you from the regulation, that it's limited to a physical presence. So it raised the issue of, are these electrons sufficient to create a physical presence?
If we didn't have this regulatory guidance, we'd have a statute that would be controlled by the Supreme Court law and probably retroactive, at least I thought the decision in Harper Thomas's decision seems to make it retroactive. If you lose the retroactivity argument, you still have this argument that the reg limited them to Quill, right? The reg somehow limited the statute and the collection of taxes to Quill, right?
Absolutely.
So explain why, when I asked Assistant Attorney General Green the question, the tax to the extent Quill allows under the Commerce Clause, that regulation, why isn't that divorced from any constitutional interpretation? She points to the other regulation and the words of the taxing statute. Why are you right and she's wrong?
Well, when the commissioner acts pursuant to the enabling legislation to create a regulation that, in effect, is seeking to implement the underlying statute, and makes the statement that this is limited by the physical presence standard, then the commissioner is bound by his own regulation.
He says that's only tied to the jurisdictional issue.
I mean, I read to the court the language. It doesn't speak to just a jurisdictional issue. It says, the language says that it will be enforced to the extent that the physical presence rule allows. It doesn't speak to a jurisdictional limitation. The other factor that I'd comment on, Justice Kafka, is that the Internet Tax Freedom Act is a further bar to the enforcement of this regulation. This regulation is specifically targeted toward internet vendors. In fact, the very title of the regulation is the Internet Vendor Rule. And the rule does not apply to catalog companies that may have more than $500,000 in sales. They are not covered by it. It doesn't apply to telephone sales that originate from out of state. And the Internet Tax Freedom Act specifically was targeted at not having states' legislation or regulation that affects only internet sales and doesn't affect other forms of remote commerce sales.
Is that issue before us?
It is before you. It was before the Appellate Tax Board. It was not the basis on
That
which...
was the wrong answer.
I believe it is, and in fact, this court invited amici to address that issue. So I think that the court recognized the fact that it's an important matter. It's a critical...
You're saying that this, if it is applied in this way, that there's a disparate treatment between internet companies and the mail order companies?
Exactly.
Okay.
Exactly. You know, and I think when we're talking about mail order companies, the Quill case said you can have catalogs that are located in the state, which are much more tangible than these electronic, invisible elements, and that doesn't create a physical presence. And it was a bright line. The reason why the court stood by the line of cases, the Bellis Hess Quill line of cases, is that they said a physical presence is having employees, having stores, having warehouses that are located within the state. And that's what ultimately in Wayfair the court concluded was the problem, that we no longer believe that physical presence is the relevant standard to be applied in this electronic age, and that instead we should look at an economic presence standard.
I have sort of a basic question. What is the sales volume statute that caused U.S. Auto Parts arguably to have to require, you know, there are these thresholds, right?
$500,000?
Yeah.
in sales?
What statute is that?
That appears in the Internet Vendor Regulation.
But what is that, actually? General Laws, Chapter?
Oh, you want to know?
Yes, thank you.
I'm sorry. It's Massachusetts General Law, Chapter 64H, Section 1.
Well, that's the definition standard. That's got the sales volumes in it as well? Is that what you're saying?
Yes, that's the regulation that contains the sales volume, that a company needs to reach that sales level of internet sales in order to be subject to the regulation.